So my talk today is about the state of liberty in Canada. In order to make my point, I'm going to start by talking not about Canada, but about a news story that occurred in another country in the summer of 2010. And the other country that was involved was Iran. And at that time, I don't know whether you'll be able to see this or not, but it was reported that there was a proposal for the Iran Ministry of Guidance. Fortunately, we don't have a Ministry of Guidance, but apparently in Iran they have a Ministry of Guidance, and they were considering a proposal that would regulate men's haircuts. And so this was published in the newspaper. There's this guy, I assume he's the minister or something, and he's looking at all these different haircuts of men that would show, you know, how they had to have their haircut. It was even going to regulate the length of their sideburns, and they were going to outlaw ponytails for men and long hair for men and mullets. I didn't even know what a mullet was. I had to look it up. A mullet is a guy that looks like this. Short hair in front, long hair sort of streaming down behind. That's the guy. And of course, nobody would be allowed to have spiked hair either. That was going to be illegal. But after this got a lot of circulation in the news, the government withdrew the plan because it just got worldwide ridicule. But meanwhile, a lot of people started bringing up other stories about the laws in Iran that had to do with grooming. And it turns out that there's lots of grooming laws in Iran. For instance, the Iranian police that summer were arresting women for wearing excessive lipstick. And sometimes they were arresting women for having too deep a suntan. And the barbershops in Iran were being ordered not to pluck men's eyebrows, even if that's what the men wanted. And of course, ever since 1979, in Iran, it has been required for women to wear the hijab. That's mandatory, outdoor wear for women. So, when you ask the question, do the people of Iran have liberty? What's your answer? No. Everybody understands that that's not a state of liberty there. In fact, we would consider that regime to be the antithesis of liberty, the stifling authoritarianism that they've got in Iran. But the question that I want to pose to you today is, how does Canadian law compare with that? Well, we have something called the Canadian Charter of Rights and Freedoms. And it has a section in it that seems to promise liberty. That's section 7, and this is how it reads. It says, everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Well, that sounds pretty good. But then there's another section of the Constitution, the Charter, that you have to look at. It says, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits as can be demonstrably justified in a free and democratic society. Well, it's a fairly simple scheme. If the legislature wants to enact a law that might infringe upon someone's liberties, it has to pass two hurdles. First, if it's going to violate liberty under Section 7, it has to pass the Section 7 test, which says the law has to be in accordance with principles of fundamental justice. So that's how we deal with objections from people like convicted murderers. A convicted murderer might say, well, you can't put me in jail because that would violate my right to liberty. But we say, look, there's this clause in there that says, if it's a principle of fundamental justice, then we can violate your right to liberty. So when you murder somebody, it's a principle of fundamental justice that if you murder somebody, you go to jail, and that's why it's okay to violate that person's right to liberty. But in cases where the federal parliament or provincial legislature decides that it wants to infringe on people's liberty, and it doesn't do it in accordance with the principles of fundamental justice, then there's a complete violation of Section 7. And the next thing that you have to do is look at Section 1 to see whether this violation of liberty can be saved, as the expression is, because it's demonstrably justified in a free and democratic society. So that's what the courts are supposed to look at when they examine the laws passed by the Parliament or the legislature. Now, how would these two hurdles apply if some politician in Canada tried to introduce the Iranian haircut law. Well, if we applied the intended scheme of the Charter, first we would look at Section 7 and say, does this law violate men's liberty? And clearly it does, because it controls how people can wear their hair. And then we say, does it violate liberty in accordance with a principle of fundamental justice? Well, no, haircuts have nothing to do with justice. There's no connection between the two. So it would be a violation of liberty under Section 7. And finally, we would look at the Section 1 test and say, is this demonstrably justified in a free and democratic society? And I think everybody in this room would say no. It has nothing to do with freedom or democracy. It's not demonstrably justified. If some guy wants to wear his hair in spikes or a mullet or you know, colored 6 different colors, that's his prerogative. If it makes him look frightening or weird to other people, he will reap the consequences. If he loses job opportunities as a result of having a weird haircut, that's you know, he will be the one that suffers. If he loses the opportunity for romantic involvements or you know, whatever other things will happen to him as a result of having a weird hairstyle, that's his problem. He should have the freedom to do that. So according to the original scheme of Canada's Charter, we should not be able to make laws outlying hairdos. But unfortunately, the simple scheme of the Charter went awry when the courts started actually looking at specific cases that came before them after the Charter was enacted. So the Charter came into effect in 1982, and the first cases on liberty started reaching the Supreme Court of Canada in 1985. And at that time, there was one woman judge. The first woman judge ever on the Supreme Court of Canada was Justice Bertha Wilson. She went on the court in 1982, and she stayed on there until 1991. And if you read her biography, she was an avowed socialist. And I have disagreed with many, in fact, probably every Bertha Wilson judgment that I have ever read, even before she went on to the Supreme Court, when she was a lower court judge, ever since I was in law school in the mid-1970s. And I think that Bertha Wilson is one of the people, perhaps the most significant person at the root of how the courts have misinterpreted the Liberty Clause of the Charter ever since 1985. In that year, they did a case that was called a reference regarding the BC Motor Vehicles Act. So there was a British Columbia law that came before the Supreme Court for interpretation. And I'm not going to tell you the details because it would just take too long. But what the court held in that case was that this BC law violated Section 7 of the Charter. It violated individual liberty, and that it could not be saved under Section 1. It wasn't justified in a free and democratic society. So they struck down the law, and I think that was the right decision for the court to make on that law. And Justice Wilson, to her credit, also agreed that that law should be struck down. But she wrote a separate concurring judgment, and in her concurring judgment, this is where things went wrong. Because here's what she said. Quote, "Indeed, all regulatory offenses impose some restriction on liberty broadly construed. But I think it would trivialize the Charter to sweep all those offenses into Section 7 as violations of the right to liberty, even if they can be sustained under Section 1. Now, her first sentence was correct. It's true, all regulatory offenses violate liberty. Every time the government says that you can't do something, or you must do something, or you must do something in a particular way, like my client, Michael Schmidt, must, before he sells his milk, he must have it pasteurized instead of selling it raw. Every time they say that, and they regulate something like that, it's a violation of liberty. But the scheme of the Charter calls for the courts to guarantee individual liberty, unless after doing a Section 1 analysis, they find the restriction is demonstrably justified in a free and democratic society. What Justice Bertha Wilson decided instead is that she really didn't like that scheme of the Charter. She said, I'm not going to waste my time doing Section 1 analysis. So to paraphrase, she said, don't bother me with all this trivia that you might bring to the court. Important people like judges shouldn't have to deal with this trivia. So even though she correctly identified that all regulations are a restriction on liberty, she said the court isn't going to treat them that way and force the legislature to justify itself under Section 1. She said, instead, we're just going to define this problem away by refusing to categorize all those regulations as restrictions on liberty. So before Bertha Wilson had her say, liberty was this huge, expansive concept, and afterwards it was narrowed down to that. I really don't know what she was afraid of. I mean, I don't know whether she thought that people would be coming to court objecting to having to drive on the right-hand side of the road or something. A challenge like that would obviously have survived as a constitutional challenge, because in a free and democratic society, it just makes sense to have having everybody drive on the same side of the road. I don't think that if she had said, yes, well, this violates liberty, it could clearly have been upheld under Section 1 as something that's reasonably, demonstrably justified in a free and democratic society. Otherwise, there'd be chaos on the roads. So I'm not sure what she was worried about people coming to the court with when she said, we don't want all this trivia coming before the court. People wouldn't likely bring trivia before the court anyhow, because it's extraordinarily expensive, as Jean-Serge and Howard know. It's very expensive to go to court, so people weren't going to be bringing this. But anyhow, I wasn't there to argue with Justice Wilson back in 1985 when she made that decision, and that decision is now part of the legal literature. So the next person to enter the picture was Justice Brian Dixon, and he was the Chief Justice of the Supreme Court at that time. And 1 year later, after Justice Bertha Wilson had made her statement, he took up the same theme in a case called The Queen against Edwards Books and Art. Now, the issue in that case was Sunday closing laws. And actually, I've heard so much about Sunday closing laws from you back here today that I wonder if I'm in the right room or not. I personally think that Sunday closing bylaws are a violation of liberty. And I was rather astonished to find that you seem to think that we should still have them. But anyhow, I don't know which side you're clapping for.
I'm clapping on your side.
Okay.
And he doesn't have a boo there.
In this case, Edwards Books and Art, there were several stores that were charged with staying open on Sundays, including a little bookstore in downtown Toronto called Edwards Books and Art. And they challenged the mandatory Sunday closing laws that existed back in 1986 as a violation of liberty under Section 7. So here's what Justice Dixon said, the Chief Justice of the Supreme Court. He said, in my opinion, liberty in Section 7 of the Charter is not synonymous with unconstrained freedom. And then he quoted Justice Wilson about how we shouldn't sweep all regulatory offenses into the Charter because it would trivialize it. And then his next sentence was, whatever the precise contours of liberty are in Section 7, I cannot accept that it extends to an unconstrained right to transact business whenever one wishes. Well, Justice Dixon didn't make any attempt to define liberty in any comprehensive way, and he didn't attempt to define the borders or the contours, as he called them. What he said was, essentially, I'll know a breach of liberty when I see one, and preventing someone from selling books on Sunday is not a breach of anyone's liberty. Now, to my mind, he just pulled that out of his own head. It was nothing but his own opinion. He didn't cite any other authorities on the subject. He didn't seem to have consulted a dictionary. He just consulted his own gut feeling. And his opinion is, kind of interesting since it became the law, but it happens to conflict with the dictionary meaning in every dictionary that you can look in. So, for example, the Merriam-Webster Online Dictionary has 4 definitions of liberty. They are, first, the power to do as one pleases. Second, freedom from physical restraint. Third, freedom from arbitrary or despotic control. And fourth, the power of choice. Well, I don't know about you, but these definitions sound an awful lot to me like unconstrained freedom, which Justice Dixon said we don't have. And in saying that, for the next 26 years, he has set the stage for all the Canadian jurisprudence. And that phrase of his, whatever else the contours of liberty may encompass, it doesn't encompass the right to do business whenever you please, that has been repeated time and time again in case after case after case until it has become like a mantra of Canadian law. And going back before the judges and trying to convince them that Justice Dixon and all his colleagues have been wrong for 26 years is a rather difficult task. So let's have a look at some of the cases that have discussed the question of liberty after applying Justice Dixon's reduced definition. In a case from 2003, the court held that liberty does not include the right to use recreational marijuana in the privacy of your own home. Now, keep in mind that if they had thought about the scheme of the charter, they could have said, yes, the marijuana laws violate your liberty, but we think they're justified in a free and democratic society. I wouldn't even have agreed with that statement, but they didn't even say that. They just said they don't violate liberty, which is patently false. Clearly, the law against smoking marijuana does violate liberty. If you think it's justified, we can then have a debate on that, but you can't have a real debate about whether it violates liberty or not. Clearly it does, but the courts say it doesn't. And in another case in 2004, they told a doctor, Dr. Massani, that liberty doesn't include the right for him to practice his profession as a doctor. Well, that's pretty puzzling. And in a 1987 case, they told a group of Calgary police officers that liberty does not include the right to hold more than one job. So there's all some pretty puzzling decisions. And then there's a whole series of cases in which the courts have considered the question of economic liberty. And usually this revolves around the right of people to enter into some occupation or other without having to buy quota or without having to get a license. And in every one of these cases, instead of admitting that, yes, these laws that require licensing and these laws that require quota, yes, these are a violation of liberty, but we think they're justified under, in a free and democratic society, which we could then have a debate on. Nope, they've just said economic liberty is not part of liberty, economic freedom is not part of liberty, and property rights are not part of liberty. So this has become like a mantra that the courts just intone. Liberty does not include economic rights or property rights, and that's where things stand today. And what about freedom of contract? Now that's another freedom that we've traditionally held as sacred in British common law. So I was talking about the right to freedom of contract, which has always been a traditional right here in Canada, and how the courts have treated that. In a case from 2005, the Selick case, which actually had to do with medical rights, the courts said that the claim that freedom of contract was a liberty right under Section 7 of the Charter is a novel argument. And they said, no, that's not part of liberty in Canada. So, according to our courts, what does liberty include? Well, it finally emerged in about 1988 in a case that I'm sure you're all going to be familiar with, the Henry Morgentaler case on abortion. What the court said then about liberty is, liberty, properly construed, grants the individual a degree of autonomy, just a degree, not complete autonomy, a degree of autonomy in making decisions of fundamental personal importance. So the courts have banished the trivia once and for all that stuff that Justice Wilson was complaining about, narrowed it down, winnowed it out, and here's what's left. Decisions of fundamental personal importance. So what qualifies as a decision of fundamental personal importance? Well, there haven't been very many that the court has ever found to qualify. The first one, of course, was the Morgentaler case, the decision to abort a fetus. That qualifies a decision of fundamental personal importance. And they've also found that the decision to use marijuana for medical purposes, to prevent epileptic seizures, that was a decision of fundamental personal importance, and they struck down a law to allow people to use medical marijuana. But they didn't strike it down for recreational purposes. And the other recent case in which the court found a violation of Section 7 rights was the assisted suicide case that Beth referred to earlier there, out in BC, just the decision that came out last year, where they said, yes, it was indeed the right of a terminally ill person to decide when and how to die. That was indeed an issue of liberty. So given that judicial history and the narrowing of the scope of liberty, what would you think would happen if somebody in Canada, a politician in Canada, tried to introduce the same type of laws that they tried to have in Iran on haircuts? What do you think the courts would say about that? Well, is wearing a mullet, is that a decision of fundamental personal importance? Absolutely not. Nobody would think that the right to wear your hair in a mullet is a decision of fundamental personal importance. And what about women choosing to wear a lot of lipstick? Or what about women choosing to get suntans? Or what about men who want to have their eyebrows plucked? None of these are decisions of fundamental personal importance. So if those cases went before the courts in Canada, they would say, that's not part of liberty. Go ahead, legislature, do your worst, make those laws if you want. We will not rule those laws unconstitutional. So in other words, Canadians have no more constitutional liberty than Iranians do. And with more and more people coming to Canada from countries where that type of very personal infringement is routine, I would not be surprised to start seeing politicians who will want to be making laws like that. And we will have no constitutional defense to that. So there's a couple of other problems with the court's analysis. I want to look at the phrase, decisions of fundamental personal importance. And my concern about this phrase is that it's not an objective test by any stretch of the imagination. It's actually a completely subjective test. Because we all have different things that we think are of personal importance to us. What's important to one person may be a matter of considerable indifference to somebody else. Or even within one person's own lifetime, something that's important to you when you're 21 years old may be of no importance to you when you're 65. So it's a subjective test, and any time that a court adopts a subjective test to be implemented in law, it spells trouble. Even the case where they said it's a decision of fundamental and personal importance, even their abortion case where that was established as a standard, you have to ask, is the decision to abort a fetus a decision of fundamental personal importance? Now, abortion is a very touchy subject, and I'm sure that people throughout this room will have all sorts of different opinions of it, and I don't want to debate the merits of the subject, but for my purposes today, it doesn't matter which side of the debate you're on, because I just want to reiterate that what the Supreme Court said was that, yes, it is a decision of fundamental personal importance as to whether or not to have an abortion. But if you look at the statistics from the US Center for Disease Control, it says that of all the women in the US who get abortions, 26% are getting their second abortion, and 11% are getting their third abortion, and 7.5% are getting their fourth or higher abortion. So it seems to me that if this really were such a life-changing event in an objective sense, there wouldn't be all those women who are getting fourth and higher abortions. They must be considering it sort of like a non-event or something pretty routine. And on the other hand, what about Dr. Masani that I mentioned earlier? The doctor who was told by the court that the right to practice his profession of medicine is not part of liberty. That man lost his license to practice for 5 years because he engaged in a consensual sexual relationship with someone who was a patient. And in Ontario, the law says that medical personnel and patients cannot engage in romantic or sexual relationships, even if it's consensual. And the medical professional loses his license for 5 years if he does that. Zero tolerance. And Dr. Masani went to court and said, that's a violation of my liberty. This is a decision of fundamental personal importance to me. I went through years of medical school. This is my living. This is how I raise my support my family. This is what I do as my chosen life career. This is a decision of fundamental personal importance to me. The court said, no, it's not. We don't think so. And they said, not liberty, and the law is valid. They could have said, yes, this is part of your liberty, but we think that the law is justified under Section 1, demonstrably justified in a free and democratic society, and then we could have had a debate about it. But that's not what they said. They said it's not part of liberty, and it's just bizarre. So there's some other parts of this that are strange, and the whole test is a problem for other reasons. First of all, it's absurd to think that minor violations of liberty, if you stack them up high enough, still allows us to be a free people. If you pile up those minor violations of liberty high enough, they add up to a full-blown case of abject subjugation. Suppose, for instance, that the government tried to tell us what time we had to get up in the morning, how often you can go to the bathroom in the course of a day, how many hours of television you can watch, how many times you had to chew your food before you swallow, or what color clothing you had to wear. I think most people would agree that none of those things that I've mentioned are decisions of fundamental personal importance. Every single one of them individually is a trivial matter. But, and so none of those things would make the cut for being something that the court would say is a violation of liberty. But when you put them all together, if we really did have laws that intruded upon our personal lives in such a manner, I think we'd all agree that we would be living in an intolerable dictatorship, not a free country at all. And another problem with the courts, that the courts have adopted. Why allow us to make the big important decisions in our lives, but not the little ones? If we're never permitted the responsibility of making little decisions, how will we ever acquire the wisdom, the judgment, and the experience to handle the important decisions when they finally come along? Those are the ones that they say we can make. When the time finally comes for us to make a decision of fundamental personal importance, how will we handle that if we've been treated like sheep all along? And finally, my third problem with this concept. Who are these people who are going to decide for us if we can't make all these little decisions ourselves? Is it going to be our politicians? Because the day before a politician is elected, that politician is deemed too stupid or too irresponsible to make those decisions for himself, just like all the rest of us. And then the day after he's elected, suddenly he gets to make those decisions for everybody. Well, how does that happen? How does that transformation happen overnight? Obviously, it's absurd. So for politicians to be making all these little decisions for us, and for us not to be making those little decisions for ourselves, is just absurd. And I just want to turn briefly now to the issue of economic liberty that the courts have ruled out entirely. The courts have always said that if you can go to jail for something, it is a liberty issue. And most regulatory offenses, like I mentioned before, my client Michael Schmidt, who is a campaigner to be able to distribute raw milk, he actually wouldn't go to jail if he's convicted of selling raw milk. He's just fined. So that's not considered to be an infringement on his liberty. If it's something that you can actually go to jail for, then they concede that yes, being locked up is indeed an infringement on your liberty. But even that distinction between paying a fine and going to jail is, in my mind, a very silly distinction. Because what happens when you save enough money to pay your fine? Well, you have to spend your life working in order to earn the money with which you will pay your fine. And if the authorities then take that money away from you, it's tantamount to their saying, we're taking away that portion of your life that you spent earning that money. It's just as if they said, for that time that you spent earning that money that we're going to fine you for, you were a slave of the state, because we're taking that away, or you were just as bad as being in jail. You might as well have been in jail and not earned it, because if you've earned it and they take it away, you might as well not have had that time. So in my view, this distinction between an offense that garners a fine versus an offense that garners a jail term is an artificial distinction. When you pay a fine, that is a violation of your liberty. And sometimes those fines can be huge. Like Michael Schmidt that I've spoken of, he faced a fine of $5,000 a day for something that he did for over 20 years. So that's $36 million in fines. I mean, that's pretty clearly, if they had tried to get that money out of him, that would have clearly been a pretty serious impact on his life. It's also bizarre to think that economic freedom can be divorced from other freedoms. The two are so intertwined that they really cannot be separated. If somebody has the right to deprive you of your property, if you have no right to retain what you've earned, if they can take away your food, your clothing, and your shelter, then it's pretty silly to pretend that they haven't interfered with your life. And there's an interesting correlation. The more comprehensively the state tries to deny economic freedoms, the poorer its people become, and the more they want to leave. People are motivated to seek economic freedom for themselves far more than they're motivated to seek any other type of freedom. People who get on some smuggler's leaky boat to make a desperate attempt to get to a more prosperous country, they're not usually seeking the right to vote. They're usually seeking the right to earn a living. So if you deny people economic freedom, they will try to escape. Now, North Korea is probably the least free country in the world, economically. And it's right next door to a country that is relatively free. So here's what you get when you deny people economic freedom. You get this so-called demilitarized zone between North and South Korea, where there's fences of barbed wire and people patrolling whose duty it is to shoot anybody that tries to leave the economically unfree country. The Fraser Institute has a publication that it puts out called Economic Freedom of the World. And so they rank all the countries of the world in accordance with the degree of economic freedom. There's another organization called Freedom House, and they rank all the countries of the world in accordance with how many other types of freedoms they've got. Political freedom, right to vote, right to free speech, right to freedom of association, and so on. And if you compare the lists of countries, the countries that are economically free are the same countries that have political freedom, and the countries that are economic basket cases where they're over-regulated and every aspect of people's economic liberty is taken away, they're the same countries that have no right to speech, no right to association, no right to vote, and so on. The two of them just can't be separated. So it's a mystery to me why Canadian courts don't recognize economic freedom as part of our charter liberty, and they're doing a disservice to all of us when they do that. And I'll be making these arguments that I've made today in court, but I must say that so far it's pretty difficult getting a judge to even listen to them, let alone agree with them. So we have a huge uphill battle. I actually think that what we need in this country is a philosophical revolution. I mean, the problem is so ingrained that we have politicians. Somebody referred before to Stephen Harper was a great speaker when he was in National Citizens Coalition, and look what he's done when he's in government. The problem is that the government is so enormous already, and it does things in so many different spheres that for somebody to go in and try and move into that and suddenly shrink it, it's almost impossible. You get caught up against, even within Stephen Harper's own party, for instance. If he says, I want to reduce government in this sphere, there'll be some backbenchers in his caucus that will say, oh, you can't do that because the people in my riding have a vested interest in this. And so he's fighting with his own internal politicians, and it is already so huge that, assuming that any particular party or politician is going to be able to change it is futile. And there needs to be a vast philosophical revolution.
What about the idea of, at the very least, defunding all the NGOs? I mean,
I would defund almost everything.
Yeah. Well,
when somebody here says there's not very much that government should do, I retreat to the Ayn Rand position. Government should, national defense, the police, and the courts, and that's it. Government shouldn't run the roads, government shouldn't run the schools, government shouldn't run healthcare. I disagree with a lot of what was said here earlier about, we have to reprioritize healthcare. We have to privatize healthcare 100%, not a little bit, not make sure that there's a safety net. All of that stuff, if you keep on surrendering to this idea that there has to be a safety net, you surrender bit by bit your freedom, your money, and your principles. And that's not a principled position to take, and I never take it. Hear, hear.
Hi, thank you. I really enjoyed your speech. I have a question to ask, but Tom Black can express it so much better. So, Tom, would you mind?
How do you know what Tom's going to ask?
I just know.
Not even his wife.
Hi, Karen. I'm president of the Landowners Association at the moment.
Louder!
Loud, can't hear you.
Louder! Okay. We were considering doing judicial reference on some of the litigation. We created a litigation fund to do a reference, or at least to do some kind of litigation. And people have advised us that judicial reference would be a good way to go on some of this legislation. The one we're thinking of at the moment is the OSPCA. Can you tell us what the chances of that is, of being successful in the sense that is that the way to go? I don't mean to decide that today, but is it a good system of approach? We just get clobbered.
I know that there's a lot of problems coming up with OSPCA because I get these phone calls. We get people asking us to take these cases, and I know about the case that Curtis Andrews has had there in the Ottawa area. The problem with proactively asking a court to strike down legislation is that essentially you're bringing a civil action against the government. And if you lose, then they get to claim costs against you. So, there goes your litigation fund. Our strategy now is wait until somebody gets charged with something. You get charged with a regulatory offense and you have to defend yourself against the charges, then you can make your constitutional arguments, and it's not considered a civil case, it's considered quasi-criminal. I just found out recently that the Ontario government's lawyers, they don't even docket their time when they're dealing with a regulatory offense like that, because there's no possibility of their claiming costs against you. So you can sort of play for free in the courts, provided you get somebody who's willing to accept the penalty, and that's always the difficult thing. I mean, Michael Schmidt that I referred to before, Michael has made huge sacrifices in his personal life to take on this battle, and he has said, I'm going to make this my life's battle. But he's basically gone the Gandhi route, says I own nothing, so that if I get clobbered, they can't take anything away from me. So you have to find some. You either have to violate the law in such a minor way that if they ding you with a penalty, it's going to be $1,000. There's something that you can that won't kill you, or you have to find somebody who's prepared to take on that.
I thought there was some cases where some cases where they actually the justice would look at it as something that should be heard in the for the sake of society, because it's been challenged, and there's no charges held against you for the cost of the court. Is that happening?
Costs are always in the discretion of the court. So if the judge thinks that you have you've brought forward some valuable argument that it was in society's interest to be heard, they can order that you not pay costs even if you lose. But I wouldn't want to stake my...
So you don't get that up front? You don't get that judgment up front?
No, there are a few different programs that, where they will possibly advance you some litigation funds, but I haven't even looked into that because that's not.
Thank you very much.
Okay, in a case like mine, which you weren't my lawyer, but you still were a very valuable source of advice, but the government backed out 3 weeks before trial. They were heading towards a losing case, part of which was a notice of constitutional question that I got a lot of help from, or a lot of help on. If we do the get charged to get the regulatory offense and go to trial, how do we force them, or is there any mechanism to force them to actually follow through and go to trial? Because I didn't have a say in the withdrawing of the charges. We were heading towards a fairly nice case of showing what the government was capable of, and 3 weeks before they said, okay, we're not playing anymore. Sorry.
Yeah, well, not too many people, I think, would grab the situation the way you did and say, I'm going after these guys and I'm going to show them. I think most people would have been really glad when the charges were dropped and just walked away. So, I mean, I don't know how you don't have any right to force them on once they've charged you. I mean, if they want to drop the charges, they can. Interesting question that you don't get compensated.
But it forces a problem on the other side of doing Tom's argument, where you find somebody who has been charged, where you're good and sure that this is a violation of their liberty. You pursue it, and it's going to take 2 years, as we found out. It takes a couple of years to get to court, and then they pull out at the last second and leave you with the bill for whatever you've spent. And I could have spent tens of thousands if I hadn't done an awful lot of work with folks like Tim. But we don't have a way of driving them through to actually follow through to trial.
I suppose it's conceivable in a case like that on the day when the judge actually, when they appeared in court to say that they're withdrawing their case, it's conceivable that you might have asked for costs. But I don't really know whether the court has discretion to order costs in a case that really isn't a civil case. They're such weird animals. They're not really criminal. They're not really civil. They're sort of, they call them quasi-criminal, and I don't know, I'd have to do some research to see whether anybody ever has forced the government to pay costs in a case where they, made the person go through all this expense and then back out at the last minute. I don't know of any. I think there were, yes.
For the last 20 years, I've been sort of listening off and on to Supreme Court decisions, and I've had my suspicions, but you sort of confirmed them today, that some of these judgments have much more to do with personal opinion and almost political opinion. Is not the big problem that there's no accountability to for the Supreme Court judges?
Yeah, that's a big problem.
How do you deal with that? Should they be elected?
By who?
By us.
Judges. Do you know the law? Karen knows the law, but I don't know the law. We are recipients of the law, but are you?
But they make the law.
Yeah, but the thing is, are you capable of judging who should make the law?
Well, are you capable of judging who should be Prime Minister? I think it's the same point.
I've actually suggested, and I've written about this in Canadian Lawyer Magazine, that instead of having judges who are appointed and are the only people who can be the judges, I think that what we should do is allow people who are learned in the law, presumably those would be lawyers, but people to go on panels so that they can have their law practice if they want, on the one hand, and then they can also, just the way mediators do, they can make themselves available as adjudicators. And I think that the people who are involved in the lawsuit, the two sides of the litigation, should be able to choose off the list who are going to be the judges. And I think that could even work with the Supreme Court. That is, instead of having a fixed Supreme Court of Canada with 9 bodies there who are always there, I think that all the judges on all the appellate courts in all the provinces, and I don't know how many that would be, it might be 100, can be on a panel, and when a case needs to go beyond the provincial appeal court level, the 2 litigants on the opposite sides of the case, or however many there are, there's usually more than 2 litigants in every case these days, can get together and choose from the short list, and there would be mechanisms the way kids choose baseball teams and stuff like that that would winnow down so that you don't always have the same people on the court, and it would allow some input by the people whose lives are at stake, the actual litigants, some input into which judges get to sit on their case. I think that would be a better system, but I've written about this, and it's just like throwing it out in the wind there.
Karen, what about the idea over there?
Andrew, and other people have had their hands up, so you've asked one question already. Yes.
2 actually.
Okay.
Harkening back a bit to what Mark and Tom have said, once you get to trial and you win your case, that doesn't necessarily mean that the law is going to be changed. Setting precedent does nothing about establishing change in law.
Well, if you set a precedent, if you go to trial and say, this law violates my right to liberty, and the court agrees with you, and then somebody in the government still comes along and charges another person with the same law that has been struck down, I've never known that to happen. Maybe it has happened in the history of time, but the government takes these things, it takes cognizance of the fact that one of its laws have been struck down. It doesn't still send the cops out to enforce that law. Not in my experience.
But isn't that how they're avoiding that situation? They get two weeks from court date, realize they're not going to win, and they brought the charges, so now there's no precedent.
Yeah.
And they've achieved their objective by embarrassing citizens.
We initially said that this is prepared speech and it will go along. Myself, like most of the people in this crowd, would have been interested in some connection to the language side where the battle is sort of uphill. The constitution side is generally connected somewhere to the political side. From your point of view, when legally it has been mentioned as Mr. Howard Kalgana's case that yes, it infringes freedom of rights and personal whatever it may be, but French goes over there. So that's one part of things. Thanks for the information of anomalies and discrepancies that you have mentioned. Could you tell us how constitutionally it could have been changed just the way it was originally made to protect and preserve the rights of the majority as a democratic country by the people, for the people, and that sort of thing? Is there anything that you could enlighten on that side?
I would have eliminated all of Section 1 of the charter there, that part about, how could it be done? I mean, we intervened in Howard Galganow's case. We intervened as, went before the Ontario Court of Appeal to support him, and the decision that the Ontario Court of Appeal came down with was...
it seems impracticable in a way that it requires the 50% majority and 7 provinces and whatnot. So
are you saying it or thinking it or agreeing with most of us the way we are thinking, that it's absolutely impossible to do anything about the Constitution and there is not a freak of chance to do and survive with the language that we are talking about?
It's certainly very difficult to change the Constitution. I'm not, don't expect to see a whole bunch of constitutional changes in my lifetime. One method that probably a lot of you here, if you're, I don't know, if you're familiar with Scott Reed and Randy Hillier and their method of trying to get that into province by province property rights into the Constitution, it's a possibility. But even now they're running up against legal obstacles where people are saying that wasn't Section 43 of the Constitution that allows you to make province by province changes.
If the original Constitution has made such restrictions, it is absolutely impossible. How could you amend? Just the way the laws are being made and we have to respect them, they are being made, and by all means, they are suitable to be changed if found unworthy. So the same applies to the Constitution, and how do we open to override the previous one?
I don't know how you would go about getting enough political support to change the Constitution, but I don't think that is the end of the story. That is, I do think that it was within the realm of possibility back in 1982 that if there had been me and Jean-Serge Brisson and Harry Galvanoff on the court and Mark Thiessen on the court, people like us, we would have come up with quite a different interpretation, and the charter would now, the charter jurisprudence would now be very different in nature. So, I mean, there's always, judges always, and always have for hundreds of years, injected their own views into the interpretation of every statute. But things could have come out differently, given the wording of the Constitution, and unfortunately they didn't, and I'm not sure where to go with that.
I heard sometime that the charter was written in such a way by Trudeau and his ilk that it can't be changed at all. I remember reading after it was passed that this is one document that doesn't matter what government comes in, there's no way you're going to be able to change it.
Well, I mean, that's always a problem with the Constitution. The Constitution is designed to be the basic overriding law of the country. And you don't want it to be, it's supposed to be, just like we talk about the Senate as the chamber of sober second thought. The Constitution is supposed to be the basic law that we can always look back to and not be governed by and swayed by the passions of the day over new things that have happened.
But isn't that what the charter did? It overrode our original Constitution for the passion of the day? That's the way I see it.
My point is that you can't have there's no point in having a constitution that you can change, by a simple majority in the House of Commons on any given day. Otherwise, you might as well not have a constitution at all. Just have the legislature, and it will make the laws, and we'll repeal whatever we want on any given day.
Well, we didn't have a constitution at one time.
Well, we had sort of the British had this unwritten constitution. Yeah, we get into a lot of constitutional theory here about what we had, what we didn't have.
Okay. How did Trudeau be able to change it?
With great difficulty, and Quebec never has signed on to the Constitution, so they're not part of it. But yeah, I mean, if you remember back to that time in the late 1970s, early 1980s, the hearings and the meetings and the drafts of all the Constitution, it was difficult to hammer out a Constitution.
Get a province signed out.
I've got a question. I've heard that the definition ab absurdo is that you cannot make a contract or pass legislation where there's a clause in it that makes it null and void. Well, as you know, our charter has two null and void sections in it, number 1 and number 33, that have been used, one by judges, one by politicians. So if it's ab absurdo, it's not supposed to be, it's not even a legitimate document to begin with because it has notwithstanding clauses in it.
Sorry, Beth, I don't get your question. I think you built a false premise into it there.
Well, have you not read the legal definition ab absurdum?
No, you're not even saying it right. It's ad absurdum, and I don't even know what you're talking about. Sorry.
Oh. Okay.
So, I mean, we can talk about that at length later on, but it's. I'm not sure what you're getting at. Yes.
If the Constitution is supposed to be, as it says at the top of the Constitution, the supreme law, how can we have a notwithstanding clause in the first place?
I think that's a good question. That's a sock to the people who want parliamentary democracy. I mean, there's two basic systems of deciding, ultimately deciding what the law will be in the country. One is to have parliamentary supremacy, and the other is to have this document, the Constitution, that will always be the final arbiter, but of course it has to be interpreted by somebody. And so we essentially, when we brought in the charter, we changed from a system of parliamentary supremacy into this system of constitutional democracy. And that was, the notwithstanding clause was the sop back to, the concession back to the people who wanted parliamentary supremacy. And we still flip-flop.
This is a comment I just made just now. When Trudeau brought this in, he actually changed Canada from being a British parliamentary system to being a French court system. So Canada basically turned over to being now legislated by the courts. They gave them the power to the judges to make laws.
But I don't know whether it's really valid to speak of that as a French system, because that's the American system.
Well, we go back before American Canada. We're going to the British civil, or the common system, the British common system, and the French civil system. I think actually the French civil system goes back to even before that with the Romans. So it converted us from the British system over to the French system. And I'm not talking English French, I'm talking the country French.
I think the better comparison is the UK and the US, because the US does have the supreme document, but even there's some discussion about whether it really was intended to be to override legislative supremacy. That's an active debate that's going on in the US circles right now.
Well, Karen, thank you very much.
You're welcome.